So hi everybody and welcome to this sample multiple choice questions for the SQE1 practice sessions with legal study skills. So today what I'm going to do is show you a couple of questions and the formatting and how we actually go about testing your knowledge for the SQE1 examination. As you can see, this is the sample question format. The front page there, welcome SQE functioning legal knowledge sample questions. So these are a random set of questions which have been set by the SRA as examples for the SQE1 examination. So we'll just have a look at a couple and see what they actually say. So the first one is on the owner of a Greek restaurant orders wall tiles that include a border design showing the Greek flag. After the tiles have been fitted, the owner notices that the tiles are decorated with the flag of Uruguay. The owner wants the tiles to be replaced. In a claim for breach of contract, which of the following measures of damages are the court most likely to award? Expectation, reliance, cost of cure, loss of amenity, mental distress. Well, I'm just going to put in the correct answer here, which I believe is the cost of cure, and we press submit and correct. That's right, up comes the correct answer. So we'll continue. So the second question, in March 2019, a claimant commenced a claim against his plumber for a breach of contract alleged to have taken place in June 2013. The plumber operated as a sole trader. In August 2019, the plumber died. So that's how long later? 6 years. The plumber assets are being dealt with by his personal representatives. In October 2019, the claimant applied to substitute the plumber's personal representatives for the deceased plumber in the claim so the claim could continue. What powers does the court have to make a substitute for the plumber as a deceased party in the claim? Can they order a new party be substituted? Court cannot order a new party. They can order a new party. Can order, cannot. Well, I think they can. So let's just have a look. So you've got these 1, 2, 3 here that say. So this one, the court can order a new party to be substituted because the relevant limitation period was current when the claimant applies for substitution. Okay, which I think sounds about right, actually. The court can order a new party to be substituted because the relevant limitation period was current when the proceedings were started. Ooh. The court can order a new party to be substituted because the relevant limitation period was current when the plumber died. I think that sounds about right. We're going to go with that one. Submit. Incorrect. You did not select the correct response. The correct answer is the court can order a new party to be substituted because the relevant limitation period was current when the proceedings were started. So my original thoughts. I'm going to kick myself, aren't I? Anyway, the next one. A man is given a bicycle as a gift. Here, he later agrees to sell the bicycle for £25 to a woman, good price, but no payment has yet been made. He subsequently discovers that the bicycle is worth £390. Whoops. He informs the woman he has no longer wishes to sell the bicycle because he was mistaken about its value. Let's see. What advice would you give the woman? There is a contract because there is executed consideration. No. There is a contract because sufficient consideration has been promised. That sounds about right. There is no contract because the consideration is insufficient. No. There is no contract because adequate consideration has not been promised. Well, no, because it has been promised. There is no contract because the consideration promised is only executory. I think there is a contract because sufficient consideration has been promised. That's what we see. Yes, hooray! So up comes the feedback. So as you can see, as we're going through this, you are actually given the actual correct answer. But you can see the quality of the questions there is published by the SRA. These are the questions one would expect if you were undertaking the SQE examination. So the last one, last month a cycle enthusiast incorporated an online bicycle accessory shop. He is a sole director and he and a friend are the only shareholders. Prior to incorporation of the company, the enthusiast negotiated a contract with a provider of cycle clothing. So this is before it was incorporated. The contract was signed prior to the receipt of the certification of incorporation by the enthusiast in his own name on behalf of the company. Oh, That doesn't sound right, does it? With whom, if anyone, does the benefit of the contract reside? The company only, the shareholders only, the enthusiast only, the enthusiast and the company jointly. No one the contract is void. Last month, a cycle enthusiast incorporated an online bicycle accessory shop. He's a sole director. He's a friend of the only shareholders. So basically, prior to the incorporation, so he is the sole director and the friend of the only shareholders. I think it should be the enthusiast only. What do we think there? Correct, that's right. You correct response. The correct answer is the enthusiast only. Right, great. So now, basically, when you're doing these questions, you can see question number 5, and there's some, I think, probably about 30 in this particular area here. You have to submit. It won't let you go on to the next. You won't go on to the next one without completing the question before submitting, and it does give you the correct answer. Okay, so this is just a sample of exactly how it works, and there'll be one area, at least one area for each of these substantive laws that you're going to need to know, and these will be added to, of course, as we go along. So I hope that's useful to you. You can see exactly how we're intending to test your knowledge once you've undertaken the revision materials.